Good day everyone, welcome to another episode in our What If series where we bring you insight in the format of a what if question on the ever-evolving landscape of employment law. I am Ross Simon from Maserumule Corporate Employment Law, and in today's episode we will unpack what if an employee is in breach of a restraint of trade and confidentiality agreement. What are the applicable legal considerations and implications? In this matter, G4S Secure, the applicant, approached the Johannesburg Labour Court on an urgent basis, seeking a final order enforcing the terms of a restraint of trade and confidentiality clauses contained in the employment agreement between it and the first respondent, Mr. Chetty. Mr. Chetty entered into an employment agreement with G4S Secure in the position of Regional Technology Manager on the 11th of March 2019. The agreement contained restraint of trade confidentiality clauses, the duration of which was 12 months with a nationwide scope. Mr. Chetty resigned from his employment with G4S Secure, effective the 31st of August 2023. The separation or termination of the contractual employment relationship was mutually agreed to and amicable. Mr. Chetty had not performed any adverse act or conducted himself in bad faith against G4S Secure to give G4S Secure the impression or suspicion that he was to breach the restraint of trade and confidentiality clauses of the agreement, sought to be enforced by either approaching or soliciting G4S Secure's clients. In other words, he had not been in breach of the terms, nor had G4S Secure suffered any actual or perceived harm in their operations or profitability after he joined Bidvest Coin, nor have they proven to have lost the clients with whom Mr. Chetty was working with since he left G4S Secure's employ. Bidvest Coin is a competitor of G4S Secure, and both are arguably the biggest role players in their specialized and high-risk industry. Ultimately, what G4S Secure seeks in the proceedings is to prevent the possibility of losing the clients that Mr. Chetty worked with, and seeks to enforce the restraint of trade during the year which Mr. Chetty would have been restrained from working with any of its competitors within the Republic of South Africa. Mr. Chetty argued that he was not privy to any of G4S Secure's confidential information, nor was he in a position to poach or take away G4S Secure's customers. Further, G4S Secure has failed to demonstrate in its papers that it has any proprietary interests worthy of protection in the context, role and occupation he held. G4S Secure argued that the protectable interest is both its confidential and proprietary information and customer connections. In the first instance, G4S Secure alleged that Mr. Chetty had access to the protectable interest in its confidential and proprietary information that has value to it. Further, Mr. Chetty was exposed to confidential and proprietary information during his employment with G4S Secure. G4S Secure further asserted that this information would be useful in the hands of a competitor such as Bidvest Coin. This is because the information is not public knowledge, as it is not in the public domain and is instead industry specific. It is alleged that this information would assist Bidvest Coin in competing with G4S Secure and allow it to lure and win over customers, thus financially harming G4S Secure and its business. G4S Secure contended that Mr. Chetty had developed a relationship with its various customers and clients. The court held that the South African contract law recognizes restraint of trade clauses limiting an employee's ability to resign and immediately take up a similar job with a direct competitor, and was generally upheld in terms of the principle under which agreements must be kept. The enforceability of the terms hinges on reasonableness. Courts apply a proportionality test, balancing the employer's legitimate protectable interests, such as confidential information or client relationships, against the employee's right to earn a livelihood. The restraint's geographical scope and duration must be narrowly tailored to the specific interest protected, ensuring that it is no wider than necessary. The court held that determining the reasonableness involved the nature of the activity being restricted, the geographical scope of the restriction, and the duration of the restriction. The court found that even though G4S Secure could have believed to possess protectable interests, Mr. Chetty established that he does not currently possess any trade secrets or hold exclusive customer connections that could potentially prejudice these interests. Therefore, in light of Mr. Chetty's lack of access to confidential information and non-exclusive customer relationships, the court concluded that enforcing a restraint of trade in this instance would not be warranted. Accordingly, Mr. Chetty was entitled to keep his position at his new employer, Bidvest Protea Coin, despite G4S arguing that he was restricted from working for any of their competitors in terms of a restraint of trade agreement. The key takeaway in this matter, colleagues, is the absence of protectable interests renders enforcement of the restraint of trade clause unreasonable and incompatible with public policy. That brings us to the end of this week's episode. Thank you for joining us, and we hope that you have found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media, and you can email me at ross@massconsulting.co.za. Until next time, bye-bye.